case today we'll be dealing with is Tata Steel Ltd versus Raj Kumar Banerjee and others. Please write the case name. The bench for today's case is Justice J.B. Pardiwala and Justice R. Mahadevan. I hope you all have revised the yesterday's case, which dealt with your Insolvency and Bankruptcy Code with the application of Limitation Act. Good morning, Bhavya. On the same line, today's case is also dealing with the Insolvency and Bankruptcy Code and Limitation Act. Okay? Can anybody tell me what was held or what was the ratio in the yesterday's case in pointers itself? Can anybody lay down the important pointers from the yesterday's case? That would be really helpful because in today's case as well, we'll be dealing those points itself. Because as an educator, as a mentor to you, my duty is to go ahead with each and every case, which according to the exam point of view is important. Even if there is repetition of the issues, because the judges are different, their opinions are different, and I have no idea on what basis the examiner might test you. And that is why I took upon these two cases, which are dealing on the same line of Limitation Act itself, though there is a different version over here, right? Very good, Prashant and Mansi. Limitation period starts from the date of pronouncement. Good. Other than that, very good, Alankriti. Very good, Swecha. Good, Mahesh. So I hope everybody remembered the important pointers. Very good. Sai, very good. This is something very important. Good, Rinjim, that is the provision. Good. Very good, Vinayak. Certified copy is mandatory or not, directory in nature. Good. Fine. So let's deal with today's lecture. We'll understand, is there any difference which Tata Steel Ltd versus Raj Kumar Banerjee is stating? Are the opinions of Justice J.B. Pardiwala is different from what was stated in the earlier case by the other judges? So we'll look into that fact. Before that, let's just deal with the facts. So the Tata Steel Ltd is a leading steel manufacturer in India. Emerged, Tata Steel become the successful resolution applicant for Rohit Ferrotech Limited. So Rohit Ferrotech Limited is going ahead with the insolvency procedure, and because of that insolvency procedure, they are calling upon the resolution plans. I hope that part which I am speaking over here, very legal, very technical words which I am using, everybody is clear about it. But then still, let me just tell you the basics of it. So whenever a company is having some financial problem, they go ahead with the insolvency. अब भाई पैसा ही नहीं बचा तो insolvent होंगे ना. So while going ahead with the insolvency procedure to help the company financially, the company calls upon the other companies to support them. So over here, Rohit Ferrotech Limited is going ahead with the insolvency procedure because they are going ahead with the financial losses every year. And because of that, now they are calling upon the other companies to invest in their company so that this Rohit Ferrotech does not go ahead with the winding up procedure, so that they are not liquidated. To protect themselves from moving out of the market, they are requesting other companies to support them. How those companies will support them? They'll help them in going ahead with the structural plan of the company. They'll put some finances over there. They'll capture the assets. They'll try to maximize the market. So these are the things which the company is required and asking from the other company. Over here, when Rohit Ferrotech Limited, being a corporate debtor, is undergoing the insolvency procedure, Tata Steel Limited had submitted their resolution plan. कि आई विल बी इन्वेस्टिंग दिस मच, मुझे इतना शेयर्स चाहिए, मैं ऐसा ऐसा करूंगा, ये करूंगा, और अकॉर्डिंगली आपके जो रेजोल्यूशन और प्रोफेशनल रेजोल्यूशन होता है, जो कि सारा जो कि आपके एडजुडिकेटरी बॉडी होती है, या मैं कहूँ तो एडमिनिस्ट्रेटिव बॉडी होती है, जो कि सब चीजें देख रही होती है इंसॉल्वेंसी एंड बैंक्रप्सी कोड के अंदर. नाउ दे हैव एक्सेप्टेड एंड अप्रूव्ड द टाटा स्टील प्लान. So the Tata Steel's resolution plan was approved by the resolution professional. Now went ahead with the committee of creditors. So the committee of creditors being the first body who need to approve it, they are required to give the votes. May I know what is the minimum vote is given as regarding your resolution plan, so as to qualify it to for the successful resolution plan? What is the percentage within which the votes of the COC is important? Let's see how many of you remember this thing. Very good, Khushi. It is 66%. Correct. Very good, very good. Good, good. So it is 66% vote which is needed for any resolution plan to become a successful resolution plan, or in a very layman term, to get approval. So in this case, the committee had approved Tata Steel's resolution plan with 98% of votes. And subsequently, the adjudicatory body, that is NCLT, the National Company Law Tribunal, has also approved it. So I believe everybody remembers what is the procedure for the same. So the simple procedure is, whenever a company is going ahead with the insolvency procedure, they call upon the resolution plans. The companies, the different companies in the market area submits their resolution plan. That resolution plan is somehow accepted by firstly by the resolution professional resolution. ठीक है? Who is the person who see कि भाई जो भी resolution plan submitted हुआ है वो within the terms and provisions of the code of 2016 है कि नहीं है, within the insolvency and insolvency के code के अंदर, 2016 code के अंदर follow हो रहा है कि नहीं. First thing first. Secondly, they will then submit that resolution plan to COC. COC has to approve it with 66% vote minimum, and then it move ahead with NCLT, मतलब tribunal का approval के साथ. Once it has been approved by the tribunal, it becomes the successful resolution plan, which will be now applicable on the insolvency wali company के ऊपर. Very simple. But there is one of the provision which is very different in cases of when any company is going ahead with the merger acquisition, when any company is going ahead with the combination with the other company, while going ahead with the insolvency procedure, they don't want the financial support over here. They are stating, let's just merge with another company. Let's just go ahead and acquire the other company, stating, let's acquire this company who is going ahead with the insolvency procedure. Now, in this case, over here, the first thing first, अभी का जब जनरल प्रोविजंस होते हैं, जहां पर इंसॉल्वेंसी प्रोविजंस होते हैं, रेजोल्यूशन प्लान होता है, तो द पावर ऑफ एक्सेप्टिंग और गोइंग अहेड एंड गिविंग द वोट्स टू द रेजोल्यूशन प्लान लाइज अपॉन द COC, right? But in cases of combination, who has the power to go ahead and approve the plan? Is it COC? No, it is the commission. CIC has the power. So prior to anything, RP जो है आपका, जो RP है resolution professional, he'll submit the resolution plan to CIC, that is the commission over here. Then from the approval of commission, the resolution plan go to COC, they'll approve it, and then it will go to the adjudicatory body. That is the procedure which is followed in cases of combination. By the word combination, I mean so merger and acquisition. ठीक है? So please remember this thing. In your exam, if the facts are regarding acquisition and merger and the approval is given by the side of COC. Oh, sorry. Thank you so much, Khushi. It is CCI, not CIEC. Yes. ठीक है? So over here, whenever the approval is given, so in generally it is COC, but otherwise in cases of combination it is CCI, then COC, and then your adjudicatory body. I hope this thing is clear. Now moving ahead. Raj Kumar Banerjee, now the fact become very important. Raj Kumar Banerjee, a former minority shareholder of the corporate debtor. So Tata Steel का एक minority shareholder is Raj Kumar Banerjee. He is challenging this approval So he is challenging the resolution plan ka approval by, sorry. Rajkumar is not from Tata Steel but of Rohit Ferrotech. I'm so sorry. So Raj Kumar Banerjee is a minority shareholder of Rohit Ferrotech Limited, and he had challenged the resolution plan of Tata Steel Limited by filing an appeal under Section 61 of IBC. He also sought condonation of delay for filing the appeal under Section 4 of Limitation Act. Over here, while appealing, he even filed the application for condonation of delay as per the provision of Section 4 of the Limitation Act. No, no. He had filed condonation of delay as per the provision of Section 4 of the Limitation Act. Wait for a second, we'll go ahead with Section 4 itself, which was allowed by the NCLAT. So NCLAT over here had allowed the condonation. He had approved the condonation under Section 4. Tata Steel Limited then appealed to Supreme Court against the NCLAT's order. So because of NCLAT having approved the condonation of delay, having satisfied whatever the reasons for the condonation of delay for appeal, this order of acceptance was agreed by Tata Steel Limited, and they went ahead with the appeal towards the Supreme Court. Now let's understand what is Section 4. Section 4 talks about expiry of prescribed period when court is closed. So whenever the last date of filing an appeal or the limitation period falls on any day when the court is closed, for example, it is on Sunday. So for that matter, Section 4 simply states that the period when the court is closed, that day will be excluded. Where the prescribed period for any suit, appeal or application expires on the day when the court is closed, the suit, appeal or application may be instituted, preferred or made on the day when the court reopens. ठीक है? I'll just wait a second. Understood? तो यहाँ पर क्या हुआ था? Rajkumar Banerjee, while going ahead with an appeal, he stated on Saturday the court was closed, and that is why I am approaching on Monday. The Saturday was the last day of filing the appeal. He took the reliance of Section 4, whereby it is stated whenever a court is closed, that day will be excluded. On day whenever the court reopens, आप उस दिन से आप उस दिन को लास्ट डे मान के अपना सूट फाइल कर सकते हैं. अंडरस्टूड व्हाई सेक्शन 4 इज टेकन इनटू कंसिडरेशन? सेक्शन 4 का यहाँ पर सपोर्ट लिया गया बाय राजकुमार बनर्जी. सिंपल सी बात है, टाटा स्टील लिमिटेड इज अ सक्सेसफुल रेजोल्यूशन प्लान वाला थिंग बिफोर दी रोहित फेरोटेक लिमिटेड. Ferrotech Limited is going ahead with your insolvency. It has been approved by COC and NCLAT, but there is this Raj Kumar Banerjee who is a minority shareholder of your Rohit Ferrotech Limited. He challenged this resolution plan and filed the appeal. While going ahead with the appeal before the NCLAT, he also stated, "Oh, I'm so sorry. There is a minor delay. I supposed to be filed within the range of 30 days, right? As according to Section 61, the appeal has to be filed within the range of 30 days. But I'm so sorry. The last day of my limitation period, that is the 30th day, fall on Saturday, which is the day when the court was closed. And that is why I am filing before this court on Monday, as per Section 4, which says whenever the court is closed, whenever it reopens, that is the day when you will file the petition, appeal or anything, taking up the matter that it is the day when you're taking the matter that it is the last date than the Saturday, because on Saturday the court was closed. This is something which was taken into hand by the or contended by the appellant. On this reasoning, NCLAT had approved it, but this approval was challenged by Tata Steel Limited. Fine. Now let's see what is happening over here. What is the issue before us? So, whether the appeal filed by the respondent number 1 was within the prescribed limitation period of 30 days, along with the additional condonable period of 15 days as provided under Section 16 subsection 2 of IBC. What is Section 16 subsection 2 of IBC? We have already dealt with Section 61 subsection 2 of IBC yesterday. And so over here it is simply stating कि क्या अपील जो कि रिस्पोंडेंट नंबर 1 ने विद इन द पीरियड प्रिस्क्राइब 30 डेज का एडिशनली वो कह रहे हैं कि कॉन्डोनेबल पीरियड जो 15 डेज का है उसके साथ इन्होंने जो करेक्ट करेक्ट यस सर गुड 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 30 plus 15 days. Over here, what happened is जो ये आपके राजकुमार बैनर्जी हैं, he filed appeal on 47th day. ठीक है, please listen to the facts correctly. Rajkumar Banerjee filed the petition, appeal before the NCLAT on 47th day, stating that there is 30 days plus 15 days, right? 15 days का condonable period है और मेरे पास 30 डेज का तो ऑलरेडी था, प्लस जब मैं अपील करने जा रहा था दैट डे वो सैटरडे, तो प्लस 2 डेज और हो गए. So accordingly he filed the appeal from the date of order of tribunal on the 47th day. So the first issue before the Supreme Court is whether the appeal filed by respondent number 1 was within the prescribed limitation period of 30 days along with the additional condonable period of 15 days as provided under 61 subsection 2. And if not, if that was not the scenario, whether the NCLAT has the power to condone the delay beyond the set prescribed and condonable period under the IBC. I hope, and as far as I remember, this issue number 2 we have already dealt in yesterday's case, right? We did dealt with this. Does NCLAT has the power under any of the rules, any of the provisions to go ahead and condone the period of 15 days beyond 15 days? Can that be done? So what is the answer to it? Can that be done? Does NCLAT has the power according to the yesterday's case? No. Okay. Very good. No, it has no such power. Why are you saying so? Why everybody is saying no? Is there any specific reason? Maximum period is 45 days. National Sport Exchange case. Give me the reason. Why is maximum period is 45 days? Correct. Even Supreme Court tribunal has no power. अब जब आप कह रहे हो नो तो ऑब्वियसली ट्रिब्यूनल हैज नो पावर, तभी आप नो कह रहे हो कि नो दैट कैन नॉट बी डन. ट्रिब्यूनल के पास पावर होती है तो आप यस कहते हैं ना. द थिंग इज over here when I'm asking why NCLAT cannot go ahead and condone a delay more than what is given over there is because of the object of your IBC 2016. Because of the object, they wanted the IBC 2016 was only executed because of the simple reason of the time-bound manner mechanism to has to be followed in insolvency cases, not to burden with court's proceedings, right? Please remember that. Okay, Sai. The thing is, the extension which you are over here talking about is of 15 days. Okay? The question is, beyond 15 days, can NCLAT has the power to extend this? So, you need to remember, no, NCLAT has no such power because firstly, it is a mandatory provision. And secondly, the IBC का जो object है, the object of the Insolvency and Bankruptcy Code is to clear the proceedings, to complete the proceedings in a very time-bound manner. ठीक है? Remember it. Very good, Pratik. Good, very good. Fine. Now, let's just deal with the opinion and everything. Before that, let's just see what are the provisions before us. So, we have already dealt with section 61, subsection 2, that is appeal before the appellant authority, that is 30 plus 15 days. Now, moving ahead, there is your 2J that talks about period of limitation. So, let us just understand what is the meaning of period of limitation and prescribed period. So, period very important. वेरी वेरी इंपॉर्टेंट. दीज टू डेफिनेशंस आर बहुत कंफ्यूजिंग है. आप कंफ्यूज हो गए एग्जाम के समय, अभी समझ में आ जाएगी बहुत अच्छे से, बट एग्जाम के समय कंफ्यूज हो गए तो मार्क दिस. 2J ऑफ योर लिमिटेशन एक्ट defines two words, period of limitation and prescribed period. Period of limitation simply means period of limitation prescribed for any suit, appeal or application by the schedule. So if you have read the Limitation Act, there is an attached first schedule to Limitation Act which lays down different periods for appeal, application and suits, right? As we have already told that there is 30 days of 3 years of time period under Article 137, right, within which the arbitration proceeding has to be initiated, right? Accordingly, there are different procedures for going ahead and for the recovery of immoral property or filing any suit in related to immoral property. The time period is, what is the time period? 12 years. If any landlord wants to recover the suit from the tenant, 12 years time period is given. In cases of mortgage property, for foreclosure or your redemption, it is 30 years. So these are the time period. These are called under the schedule, period of limitation, right? So anything which are simply given in the schedule, prima facie, कि for contract related matters, go ahead with 3 years. अगर defamation का case है tort के अंदर 1 year. तो जो time period given है under the schedule, that is period of limitation. What is prescribed period then? Prescribed period means the period of limitation computed in accordance with the provisions of this act. मतलब prescribed period is different from period of limitation. For example, the period of limitation for filing the appeal before the NCLAT according to section 61 subsection 2 is 30 days, right? But there is section 4 which exempts the day when the court is closed, and accordingly if there is an addition, मान लेते हैं 5 days के लिए court closed था. Sure, I'll explain it again. So over here, if for 5 days the court was closed, so in this 30 days, 5 days will be added by the court side because the court was closed, and because of that matter, the person who was aggrieved was unable to file an appeal. So this over here becomes 35 days. This is not something given under the schedule. Under the schedule, if we understand, under the provision under the schedule, there is 30 days which is given. But according to the provisions of this Limitation Act, it is being made as 35 days. So this is the prescribed period. Any period which is calculated on the basis of the act, according to the Limitation Act, that is your prescribed period. Anything which is given under the bare provisions of the schedule, that is period of limitation. Never get confused. Period of limitation is nothing but which is given under the schedule, जहां पर कोई एडिशन नहीं है, कोई सब्सट्रैक्शन नहीं है. बट ऑन द अदर हैंड, प्रिस्क्राइब्ड पीरियड इज एनीथिंग व्हिच इज कैलकुलेटेड थ्रू द प्रोविजंस ऑफ द एक्ट. जैसे कल हमने किया था सेक्शन 12 ऑफ लिमिटेशन एक्ट, वेयर बाय इट इज स्टेटेड द डे ऑन व्हिच the judgment is or the decree is pronounced, that day is excluded, right? तो मान लेते 30 days है, तो उसमें हमने फर्स्ट डे एक्सक्लूड करा. फिर उसमें था कि अगर जितने समय आपको लगा टू गेट द कॉपी ऑफ द ऑर्डर, the time which is being taken by the court in giving the order is also excluded. So these things which are calculated according to the provisions of the Limitation Acts, they are called prescribed period. Understood? Everybody understood this thing? Very, very important. In your exam, there might be questions as to what is prescribed period. So never get confused with this thing. Prescribed period is calculated according to the provisions of the act, and period of limitation is nothing but which is given under the schedule. Fine. 30 days आपका period of limitation हो सकता है, और अगर हम calculate करें according to what all under what all facts I am excluded, तो उससे हो सकता है 60 days का हो जाए. That is something very different and which is calculated according to the provisions of the act. Fine. Now moving ahead. There is NCLAT का Rule 3, which talks about computation of time period, where a period is prescribed by the act, and these rules or under any other law or is fixed by the appellate tribunal for doing any act in computing the time, the day from which the said period is to be reckoned, that is to be calculated. Reckoned means calculated, shall be excluded. So Rule 3 over here also states कि जिस दिन से आपको अपील करनी है, जिस दिन वो ऑर्डर दिया था, वो दिन भी आपका excluded हो जाएगा. And if the last day expires on the day when the office of the appellant tribunal is closed, that day and any succeeding day on which the appellant tribunal remains closed shall also be excluded. So this over here is the prescribed period. 30 days में जब calculate करेगा aggrieved person, तो वो ये सब डे exclude कर देगा. First day on which the order is given, अगर कोई court close है, accordingly over here the aggrieved party, that is the, what is the name? Raj Kumar over here has stated this only, कि I am taking the reliance of section 4 of Limitation Act, whereby the court was closed on the last day of my limitation period, that is 30th day, and now according to my prescribed period, Monday तक मैं appeal कर सकता हूँ, and accordingly I am filing the appeal before the Supreme Court, sorry, NCLAT. NCLAT on that ground had accepted the appeal. Now moving ahead. So the opinion of Justice J.B. Pardiwala. The court, in view of the above facts, noted the benefit of Section 4 of the Limitation Act and Rule 3 of NCLAT extends the limitation period to the next working day if the prescribed period expires on a holiday. Correctly said. तो जो भी next working day होगा उसमें आपका period extend हो जाता है अगर आपका जिस दिन भी आपकी holiday हो. So if the prescribed period expires on the holiday, fine. The court said that the benefit of exclusion of period during which the court is closed shall be available when the application is filed within the prescribed period of limitation and shall not be available in respect of period extendable by court in exercise of its jurisdiction. Can anybody explain me this paragraph? What over here court is trying to say? इसमें जो उन्होंने according to the aggrieved over here, the appellant over here, उसके accordingly वो है 15 day वाला last day, उसने 30 day वाला नहीं calculate किया है, यहाँ पर 45 days वाला calculate किया है. ठीक है. The court, very good. The court said that the benefit of exclusion of period during which the court is closed shall be available when the application is filed within the prescribed period of limitation and shall not be available in respect of the period extendable by court in exercise of its discretion. Correctly said. Yes, 47th day पे appeal हुई थी. Let's just clear the facts again. The thing is 30 plus 15 days का हमारे पास टाइम होता है to file an appeal before the NCLAT. यहाँ पर जो aggrieved है उन्होंने फाइल किया है on 47th day. ठीक है, he filed on 47th day stating कि I had this 30 days plus I had this 15 days and ये 15 day का जो last day था उस दिन Saturday था, that fall on Saturday. Saturday Sunday 2 दिन off हुए तो plus 2 days more, and that is why I am coming on 47th day, which is valid according to him. That is what he is stating. Fine. Because we have studied yesterday's case, we are studying today's case, we'll understand, is this the right calculation on the part of the aggrieved, or is this the right calculation, because NCLAT has also followed this calculation itself. So we need to see कि यहाँ तक आपका मिलेगा 2 days का extension कि यहाँ से आपको 2 days का extension मिलेगा. ठीक है, that is what we have to see in our case कि जो 2 days का extension मांगा जा रहा है that the court is closed, इसलिए तो ये यहाँ से calculate होगा from the 30th day, from the statutory period, or from 15th day. Fine. Are we clear on this point? Are we clear on facts? Fine. So अब facts पर अब थोड़ा सा opinion समझते हैं तो अच्छे समझ में आएगा. The court said that the benefit of exclusion of period, जैसे कि section 4 in this case, during which the court is closed shall be available when the application is filed within prescribed period of limitation and shall not be available in respect of period extendable by court in exercise of its discretion. So if you are asking about the extension of closure कि भाई court closed था तो you should have followed 30 days वाला period which is given and not which is given under 15 days के अंदर. So court over here prima facie has rejected this contention stating कि कि जो आप एक्सटेंशन मांग रहे हो वो स्टैट्यूटरी पीरियड से अप्लाई होगा, नॉट फ्रॉम द पीरियड वेयर बाय द कोर्ट हैज अ डिस्क्रिशन. I have yesterday told you that this 15 days can be extended. That is the maximum extension. That is not the extension which is given in every case. In this behalf, the NCLAT can go ahead, okay, there was a failure of 2 days from 30 days, okay, 2 days extension will be given. There is no such requirement that the whole 15 days will be allowed. Until unless there is 15 days extension required from the part of the appellant. Fine. So the court over here is stating the benefit of any of the provisions of Limitation Act, any of the rules will be applicable only when the statutory period के अंदर within that the application is filed. So for example, 30th date fall on Saturday. If the 30th day fall on Saturday, then you can get 2 days of extension as per the Limitation Act. But you cannot go ahead with the fact कि 15 days आपने खुद के अंदर ही ले लिया, because this is condonable. This is something which the court has a discretion to allow it. So I'll take that as my matter of right. ठीक है? This 15 days as an extendable period cannot be taken as a matter of right, but rather it is the power of the court. It is the discretionary power of the court. So please remember it. Understood? Moving ahead. In the present case, the respondent number 1 was neither a party to the proceeding before the NCLAT tribunal nor privy to the COC deliberations and became aware of the order only upon its subsequent disclosure. So firstly the thing is कि जो आपका respondent number 1 है, he was neither the party to the proceedings before the NCLT जब court file हुआ, ना ही COC के deliberation में, and became aware though he got to know about the order subsequently. However, it is evident that the company secretary of the corporate debtor जिस कंपनी के वो minority shareholder है, उन्हीं के company secretary में duly informed the listing departments to both National Stock Exchange and Bombay Stock Exchange about the tribunal's order dated 7/4/2022. ठीक है? Over here the thing is, though this part is not so relevant, but then still I have added here. इधर था कि respondent number 1 is neither the party to anything, though he subsequently got to know about the order of the NCLT. The thing is कि यहाँ पर I was not the party to the NCLT order. I was never the party to the proceedings of before the NCLT. But so for me, when will be the your limitation period will start? So that is the question. So over here, the party respondent number 1, though not being the party, he got to know about the order immediately. Why? Because this order of the NCLT was made available to both National Stock Exchange and your Bombay Stock Exchange within 30 minutes from its pronouncement. तो कंपनी सेक्रेटरी ने उसी कंपनी के तुरंत ही इंफॉर्मेशन पास ऑन कर दी थी on that day itself within 30 minutes. Hence, for the respondent as well, though he was not party to the proceeding, the limitation period for filing the appeal commences on that day itself, 7/4/2022, and thereby expired on 7/5/2022. Notably, 7/5/2022, that is the last day of limitation period, fell on the first Saturday of the month, which is a working day for the registry of NCLAT. Very important. Over here, the respondent was stating that because the last Saturday, the Saturday fell on the non-working day, and that is why I am taking 2 days of extension, is not valid. Why? Because Saturdays are the working period for the registry. So registrar works on the last days. Understood? दो यहाँ पर 30 days का कैलकुलेशन किया गया है. अगर आप यहाँ देखोगे फैक्ट्स के अंदर 30 days का कैलकुलेशन किया है, बट देन स्टिल जो आगे का भी दिन जो फॉलो हुआ उस दिन भी सैटरडे ही पड़ा था. तो कोर्ट बस इस चीज को एक्सप्लेन करने की कोशिश कर रहा है कि सैटरडेज आर वर्किंग डेज फॉर द रजिस्ट्रार, एंड फॉर दैट मैटर यू कैन नॉट टेक अप Saturday as a closed the non-working day for the court, and thereby Section 4 will not apply. Understood? The court added that the benefit of Section 4 of the Limitation Act cannot be granted as the respondent filed the appeal beyond not only the prescribed period of 30 days, but also the condonable period of 15 days. The court added कि इवन इफ आपने उस दिन भी कर दिया होता, बट नाउ सेक्शन 4 का बेनिफिट तो रिस्पोंडेंट को बिल्कुल भी नहीं मिल सकता, बिकॉज ऑफ द सिंपल रीजन he had filed appeal not beyond the prescribed period, not beyond the statutory period 30 days, but also beyond the condonable period of 15 days. In view of the same reason, Rule 3 of NCLAT rules has also no application to the facts of the present case. तो यहां पर भी था ना, रूल 3 क्या बोल रहा था, द डे ऑन विच द ऑर्डर इज प्रोनाउंस उसको आप एक्सक्लूड करो, द डे इफ एनी लास्ट डे ऑफ द लिमिटेशन पीरियड फॉल्स ऑन योर नॉन वर्किंग डे तो उसको भी एक्सक्लूड करो. दैट इज इवन नॉट फॉलोइंग ओवर हियर, as the respondent number 1 filed the appeal beyond the statutory maximum period of 45 days prescribed under section 61 subsection 2 of IBC. So over here respondent had done an erroneous work whereby he had not only filed within the statutory period but beyond the statutory maximum period. So statutory period के अंदर नहीं, बट स्टैट्यूटरी मैक्सिमम पीरियड के बियॉन्ड उन्होंने फाइल किया. देयर इज नो स्कोप विद इन विच कोई भी चीज का हम क्या कहते हैं रेक्टिफाई कर सकते. दिस मिस्टेक ऑफ द रिस्पोंडेंट ओवर हियर कैन नॉट बी रेक्टिफाइड because there is no provision under the law, there is no interpretation under the law within which, with the help of which this can be rectified. Furthermore, the court observed that the IBC prescribes strict timelines for filing appeals and taking legal actions so as to ensure that insolvency proceedings are not misused to recover time-barred debts. And the proviso to section this clearly limits the NCLAT's jurisdiction to condone delay only up to 15 days beyond the initial 30 days period. So the court over here observed that the IBC follows a very strict timelines for the appeals and taking legal actions. For what? To ensure that the insolvency proceedings are not misused to recover the time-barred debts. And even the proviso over here simply states that the NCLAT has the jurisdiction to condone delay only up to 15 days and beyond the initial 30 days. Up to only लिखा है मतलब कि not beyond 15 days. Further, are we clear? Are we clear with this thing? Further, where a statute expressly limits the period within which the delay may be condoned, the appellant tribunal cannot exceed that limit. So over here, when a statute expressly limits the period जिसके within आपका delay होना ही, जिसके within आपका condone होना चाहिए delay, the appellant tribunal has no right to exceed it. कल हमने ये चीज देख ली थी. In other words, the NCLAT, being a creature of statute, operates strictly within the powers conferred within it. So NCLAT is a statute created creature, ठीक है, of which he requires to operate strictly within the powers conferred upon it. Unlike a civil suit, it lacks inherent jurisdiction to extend time on equitable ground. So unlike the civil suits, the court of NCLAT has no such inherent jurisdiction to extend the time on equitable ground. Very important. अभी we'll see the case law itself, यहाँ पर ये चीज की गई थी. जैसे कि कल हमने पढ़ा, सुप्रीम कोर्ट has no such power under the article, under the article 142 था, कौन सा था, हाँ ठीक है. Similarly over here, NCLAT has no such power of inherent jurisdiction to extend the time. The court was of the view that the orders passed by NCLAT condoning the delay in filing the appeal is ultra vires and liable to be set aside. So over here, court is of the view कि जो order NCLAT ने दिया है, accept किया है, जो condonation of delay is ultra vires and liable to be set aside. And observe, very important thing over here, this thing, that time is of the essence in statutory appeals, and the prescribed limitation period must be strictly adhered to. In cases of appeal, the time is the essence, and thereby this period of limitation should be strictly adhered to. Liberal approach cannot be taken into consideration while in going ahead with the appeals. And similar is the position for petitions, but for petitions there might be some linear approach can be taken. ठीक है, linear approach can be taken in the cases of petitions against anybody else, but in cases of appeal whereby the party already had a prior knowledge that there is this order passed, in that scenario you can only have the provisions of limitation act, whereby if your facts fall under any of the provisions of limitation act, you can go ahead and exclude the period of limitation. Otherwise, what is required that this period of limitation should be strictly adhered. Even a delay of single day is fatal if the statute does not provide for its condonation. If the statute does not provide for the condonation, then even a single day's delay is a kind of fatal. Why? Because these proceedings are governed for the commercial purposes, right? There is the commercial world which are governed by these proceedings. This is not something which is right in personam. Okay? These proceedings are generally right in rem, whereby the commercial acts of the parties, the commercial acts of the companies are somehow affected. To protect that, what is required? Certainty. The commercial world requires certainty, and because of that matter, the time becomes an essence, and thereby even a single day's condonation becomes fatal. Thus, the NCLAT has no power to condone delay beyond the period stipulated under the statute. Allowing condonation in such cases would defeat the legislative intent. The legislative intent is to speedier the process, okay, and open the floodgates to belated and potentially frivolous, useless petitions, thereby undermining the efficacy and finality of the appellant mechanism. If this is allowed, if a linear approach is taken in cases of filing appeal, condonation is given so easily, then what will happen? Every useless petition will be followed. जो पुरानी petitions रह गई थी कि अच्छा अब तो मेरा अब तो मेरा limitation period हो गया, I cannot go ahead with the appeal, they will also file the appeal thinking oh, over here the appellate tribunal will allow my appeal because they are taking a liberal approach to this method. Now what will happen? It will create a floodgate. The court will be overflooded with the appeals. To control that, to give the certainty to the proceedings, to let the aggrieved over here vigilant with their rights, right? On those lines, the court over here has stated the NCLAT has no power, neither inherently not otherwise, to extend a period of 15 days beyond a single day. Understood? And it is very strict provision. The precedent before us, yeah, aapka first case is not so important. Sakufa Ahmed and others versus Upper Assam Plywood Products Private Limited and others. Over here, the expression prescribed period appearing in section 4 cannot be construed. They are defining the prescribed period. So prescribed period appearing in section 4 cannot be construed to mean anything other than the period of limitation. So according to section 4, according to 2021 case law, Supreme Court is simply stating that though section 4 uses the term prescribed period, but having said so, this prescribed period somehow means period of limitation itself. Any period beyond the prescribed period during which the court or tribunal has the discretion to allow a person to institute the proceedings cannot be taken to be a prescribed period. तो कोई भी period beyond prescribed period अगर आप allow कर रहे हो, that cannot be taken into consideration. Not so important. This is one of the case law which was referred, and that is why I have written over here. Now, 2020 का V Nagarajan versus SKS Ispat and Power Limited. We have dealt with this case law which is very important, right? See, I have told you ना, कहीं पर भी limitation insolvency आएगा, this case law will be referred because it held that the limitation period of filing appeal commences on the date of pronouncement and not from the date when the order is received or made available to the aggrieved party, right? With another thing, we have also dealt with Sanjay Pandurang Kalate versus Vistara 2024, whereby it is stated अगर आपका order एक दिन pronounce हुआ और next day website में आ गया, from that day itself, from the date of pronouncement itself, आपका limitation period start हो जाएगा. It was held that the period of to commute limitation to file an appeal under section 61 from the order of NCLT commences from the date of uploading the order by the registry, as the commencement of the period of limitation inherently linked to the date of pronouncement. Simply जो कि हम लोग ने पढ़ा था. Now, A. Rajendra versus Gonu Gunta, Madhusudan Rao and others. See, जो कल हमने केस रेफर किया, कल जो हमने पढ़ा, वही केस को आज इस टाटा स्टील के केस में रेफर करा गया. Stated that where the judgment was pronounced in open court, the period of limitation starts running from the very day. Understood? I've already told you कि please remember this fact. अगर कोई भी judgment pronounce हो रहा है in open court, the period of limitation for that matter will start running from the very day. Now, another important case of Mobilix Innovations Private Limited versus Kirusa Softwares Private Limited. While interpreting Section 9 of IBC, this court underscores the IBC's strict procedural discipline. That is, only applications strictly conforming to statutory requirements can be entered in. So while interpreting Section 9, court is stating that only the applications which are following the statutory timeline, the statutory requirements, will be only entertained by the courts. This principle is also applicable to limitations issues under Section 61, subsection 2, as it supports the idea that tribunals must operate within the bounds of the court. So within the time period which is given under 61, subsection 2 has to be followed, because Section 9, while interpreting Section 9, court has simply stated for any petition, for any application, for any appeal to be approachable to the court, what is required? The strict compliance of the provisions, without adding equitable or discretionary power not conferred by statute. So whereby it is given that this has to be followed, then that has to be followed. Nowhere you can say कि we'll add upon the equitable or discretionary power. That is not conferred to the NCLAT, to the tribunal, to the appellate tribunal. Nobody has that power. Now, dealing with the last and important case, very important case, please do remember the case name. Kalparaj Dharamshi versus Kotak Investment Advisors Limited and another. Over here, NCLAT cannot condone any delay beyond 15 days, even on equitable grounds. Even on where there is equity, where the law has to see the equitable grounds, or even on those grounds, the condonation cannot be done beyond 15 days. This is said in our case itself. The Supreme Court over here in our case has referred to 2021 judgment itself. And the appellant, and that the appellate mechanism under IBC is strictly time bound by design to preserve the speed and certainty of the insolvency resolution process. So in your 2021 judgment, simply two things were stated. Firstly, no condonation can be done on equitable grounds as well beyond the statutory period, statutory maximum period, firstly. And secondly, why is this so? The reason is that the IBC's appellate mechanism, the appeals follow a time-bound manner mechanism, whereby this has to be followed to preserve the speed and certainty as to insolvency procedure. Are we clear? These are the important judgments for you all. Now, the NCLAT order is set aside and the appeal is allowed, right? So, in our judgment for today, we have learned and understood that even beyond this 15 days, NCLAT had no power, which is reconciling with the yesterday's case. And the yesterday's case is also referred in our today's case, right? Firstly. Secondly, if you want to go ahead and take the benefit of the provisions of Limitation Act, you want to exclude any period while going ahead with the appeal, application or suit filing, then for that matter, that benefit under the Limitation Act can be taken only in the statutory period, not under the extendable period. Why? Because that extendable period is always on the discretion of the court. That is always the discretion of the court, the tribunal to allow it. That cannot be claimed as a matter of right. What can be claimed as a matter of right is the statutory period which is given. Like, for example, in this case, that is 30 days. Within that 30 days, you can ask the extension. You cannot ask the extension beyond 30 plus 15 days. Understood? Over here, the respondent filed the appeal on 47th day. He asked for the benefit of section 4, that is claiming that the court was closed on Saturday, stating the fact that after the 15th day, on the 45th day, under your 61 subsection 2, the court was closed. The Supreme Court has simply stated this cannot be done. If the respondent wants to claim any of the extension, then he has to be claimed within the last day of 30 days. That is, the statutory period has to be taken into consideration, not statutory maximum period. Understood? There are two different pointers, statutory period and statutory maximum period. For your consideration, for any benefit under Limitation Act, the statutory period has to be taken into consideration. Are we clear? Does anybody has any doubt regarding to this case? Please do remember the cases, because this case is also referring to Limitation Act, and that is very confusing. So please remember the cases. I have already marked which all important precedents you need to remember. Remember today's case, Tata Steel Limited versus Raj Kumar Banerjee. Fine. If nobody has no doubt, then I'll end the session and we'll meet tomorrow with a new case. Tomorrow we'll be dealing with the constitutionality of some of the provisions of Customs Act and your GST Act. It is very important. Okay? Thank you so much. Then I'll end the session.
Enhance legal skills. Unlock success with RostrumLegal.